Imagine this, you've been working hard at your job and one day your boss calls you into the office. They say, "We're letting you go." You ask why, but they refuse to explain. That leaves you with the big question, is it even legal to fire someone without giving a reason? In the United States, the answer often surprises people. Because of something called at-will employment. In most cases, yes, it's legal for your boss to fire you without giving any explanation. But there are important exceptions. If the real reason behind the firing is discrimination, retaliation, or a violation of public policy, then it may cross the line into wrongful termination. In this video, we'll break down the concept of at-will employment, when firing without cause is legal, when it's not, and what you can do if you suspect you've been terminated for an illegal reason. Part 1. The basics of at-will employment. To understand whether someone can be fired without a reason, you need to know about at-will employment. This is the default rule in almost every state in the US. It means either the employer or the employee can end the employment relationship at any time, with or without notice, and with or without cause. For example, if your boss decides they don't like the way you dress, or they want to replace you with their cousin, they don't have to justify that decision. Similarly, you can walk away from your job at any time without giving 2 weeks' notice, though many people choose to out of courtesy. This flexibility is why most firings without explanation are completely legal. An employer doesn't have to sit you down and provide detailed reasons, and they don't have to prove just cause, unless you fall into an exception category. But there are some limits. At-will employment does not give employers a blank check to fire for illegal reasons. If a termination is based on discrimination, like race, sex, or disability, retaliation, like filing a complaint, or violates a specific contract or public policy, then at-will no longer applies. It's also worth noting that not every worker in the US is at-will. Union members and employees with written contracts may have additional job protections. Their agreements often require just cause for termination, meaning the employer must provide a valid reason and follow disciplinary procedures. Government employees may also have stronger protections, since constitutional due process rights can apply. So, in most situations, firing without giving a reason is legal. But if the hidden reason is one of the illegal ones, then the lack of explanation doesn't shield the employer from liability. Part 2. Exceptions, discrimination, and federal protections. Even though at-will employment allows most workers to be fired without cause, there are clear exceptions under federal law that make certain reasons for termination illegal. If an employer fires someone for one of these reasons, even if they don't say it out loud, it's considered wrongful termination. The most important protections come from federal anti-discrimination laws. Under Title VII of the Civil Rights Act of 1964, it's illegal for employers to fire someone because of their race, color, religion, sex, or national origin. Over time, courts have clarified that sex includes pregnancy, sexual orientation, and gender identity. That means if a worker is let go because they're pregnant or because of their sexual orientation, that firing is unlawful. The Age Discrimination in Employment Act, ADEA, adds another layer. It protects workers who are 40 years or older from being fired just because of their age. For instance, if a company replaces a 55-year-old employee with a much younger worker, likely to refresh the team, that's age discrimination. The Americans with Disabilities Act, ADA, prohibits firing someone because of a disability if they can still perform essential job duties with reasonable accommodation. For example, letting an employee with a chronic health condition take short breaks or adjust their schedule. If the employer chooses to terminate instead of accommodate, that can be wrongful termination. Religion is also protected. Employers must make reasonable accommodations for religious practices, such as flexible scheduling for worship or holidays, unless it causes undue hardship. If someone is fired after asking for that accommodation, the employer may have violated Title VII. It's important to recognize that employers don't always state the real reason. They might say, poor performance, or restructuring, when in reality the firing was motivated by bias. That's why investigations by the Equal Employment Opportunity Commission, EEOC, are often necessary to uncover the true cause. In addition, many states have their own human rights laws that expand protections beyond federal law. Some cover marital status, sexual orientation, political affiliation, or even appearance-based discrimination. States like California, New York, and Colorado are especially known for broader protections. So while at-will employment means no reason has to be given, firing someone because of discrimination is never legal. Workers who believe discrimination played a role can file a complaint with the EECC or their state agency, often the first step before suing in court. Part 3. Retaliation. Firing workers for standing up for their rights. Another major exception to at-will employment is retaliation. Even if your boss doesn't give you a reason, if the true reason was punishment for exercising your rights, the termination is illegal. Federal laws explicitly prohibit retaliation in many situations. Under Title VII, your employer cannot fire you for filing a discrimination or harassment complaint or for cooperating in an investigation. The Fair Labor Standards Act, FLSA, protects workers who complain about unpaid overtime or minimum wage violations. The Occupational Safety and Health Act, OSOHA, shields employees who report unsafe working conditions, and under the Family and Medical Leave Act, FMLA, you can't be punished for requesting or taking medical leave you're entitled to. Here are some real-world examples. A hotel worker reports sexual harassment by a supervisor. 2 weeks later, she's suddenly fired for attendance issues, even though her record was clean before. That timing strongly suggests retaliation. A construction worker reports unsafe scaffolding to OSHA. Soon after, he's told the company is cutting back, but only his position is eliminated. That can be illegal retaliation. An office employee files a complaint about unpaid overtime. Weeks later, he's terminated for performance problems, despite positive reviews. Again, retaliation may be the real driver. The law looks at patterns and timing. If a firing closely follows a protected activity, like filing a complaint, requesting leave, or reporting misconduct, courts often presume retaliation unless the employer has strong evidence otherwise. Retaliation doesn't always mean immediate firing either. Employers may try subtler tactics, like reducing hours, demoting, reassigning to less favorable shifts, or creating a hostile environment until the employee quits. All of these can count as retaliation under federal law. According to EEOC data, retaliation is the most common claim workers file, making up more than half of all charges. That's because retaliation is often easier to prove than the underlying discrimination, since the timing and context speak volumes. So while at-will employment gives employers wide discretion, it does not allow them to fire or threaten to fire workers for standing up for their legal rights. If they do, that's wrongful termination, even if they never admit the real reason. Part 4. Contracts and the public policy exception. While most jobs in the U.S. are at will, not all of them are. Some employees are protected by contracts or union agreements that limit when and how they can be terminated. In those cases, firing someone without giving a reason can absolutely be illegal. For example, if you signed an employment contract that says you can only be fired for just cause, your employer must provide a valid explanation and, in many cases, follow specific disciplinary steps before letting you go. Simply saying you're fired without cause would be a breach of contract, and you could sue for wrongful termination. Unionized employees often enjoy even stronger protections. Collective bargaining agreements typically include detailed just cause provisions. That means if you're a union worker, Your employer must prove a legitimate reason and may even need to go through a grievance or arbitration process. In those workplaces, a firing without explanation is almost always challengeable. Then there's the public policy exception. Even in at-will states, courts generally agree that firing someone for reasons that violate fundamental public values is illegal. Examples include refusing to break the law. If your boss orders you to commit fraud and you refuse, firing you for that is against public policy. Performing a legal duty. Employers cannot fire you for serving on a jury, reporting for military service, or testifying truthfully in court. Exercising a legal right. Taking family leave under the FMLA, filing a workers' compensation claim, or reporting wage theft are all activities protected by law. Whistleblowing. Many states have specific statutes protecting employees who report illegal activity by their employers. Courts use the public policy exception to prevent at-will employment from being abused in ways that would harm society. For example, if workers were too afraid of being fired to report safety violations, dangerous practices would never come to light. It's important to note that the scope of the public policy exception varies by state. Some states apply it broadly, while others interpret it more narrowly. But in nearly every jurisdiction, there are at least some protections against firings that undermine laws or civic duties. So, while contracts and union agreements directly limit an employer's ability to fire without cause, public policy exceptions act as a backstop, ensuring that certain reasons for firing are off limits, even when no written contract exists. Part 5. How to recognize wrongful termination and steps to take. If you're let go and your boss won't explain why, it's natural to wonder if something illegal happened. The first step is to look for warning signs that the firing may not have been lawful. Start with timing. Were you fired soon after filing a complaint, requesting medical leave, or reporting unsafe conditions? Sudden termination right after you exercise a legal right often signals retaliation. Next, consider your performance history. If you consistently had good reviews, but were abruptly fired without explanation, that raises questions. Employers usually document problems before firing. A lack of documentation may point to hidden motives like discrimination. Think about whether you fall into a protected category under federal or state law, such as age, 40 plus, disability, pregnancy, race, religion, or gender. If your termination came with biased comments or a pattern of targeting certain groups, it could be wrongful termination. Documentation is key. Save emails, performance reviews, pay stubs, and any written communication about your job or your firing. If coworkers witnessed unfair treatment, ask them to provide statements. Courts and agencies often rely on this evidence to uncover the real reason for a termination. If you suspect your firing was illegal, you can file a complaint with the Equal Employment Opportunity Commission, EEOC, for discrimination or retaliation claims. In wage-related cases, the Department of Labor may investigate. For workers' compensation retaliation or public policy violations, you can turn to your state's labor board or court system. Deadlines are strict. EEOC charges usually must be filed within 180 days, though some states extend it to 300. That's why consulting with an employment lawyer can be so valuable. Many offer free consultations and work on contingency, meaning you only pay if you win. Remember, not every unexplained firing is illegal. Under at-will employment, your boss often doesn't need to justify their decision. But if the real reason falls into one of the exceptions, discrimination, retaliation, contract violation, or public policy, you may have a case for wrongful termination. The bottom line, unexplained firings are often legal, but not always. Protect yourself by recognizing the signs, gathering evidence, and acting quickly if you believe your rights were violated. So, is it legal to fire someone without giving a reason? In most cases, yes, because of the at-will employment rule that covers the majority of U.S. workers. Employers don't have to explain their decision, and many terminations happen without cause. But the law draws clear lines. If the real reason is discrimination, retaliation, breach of contract, or violation of public policy, that's when it becomes wrongful termination. For workers, the key is understanding those exceptions and paying attention to timing, patterns, and documentation. If you suspect your firing wasn't lawful, you can file a complaint with the EEC, Department of Labor, or your state agency, and even take legal action with the help of an attorney. If this video helped clarify the rules, hit like, share it with a friend who might need it, and subscribe for more plain English guides to workplace law. And in the comments, have you ever been fired without being told why?